Alrighty. Thank you folks for joining us for the employment webinar on how to hire your first employee in Vermont. This is in partnership with Vermont Law and Graduate School and the microbusiness program at CVOEO. Next slide. Just some housekeeping. We're gonna keep recording on throughout so it can live on YouTube after this presentation. Please mute yourself when you're not speaking. Enter questions in the chat. Alternatively, raise your hand and Simi and I can make sure that we get to them. And after this workshop, we'll make sure that you get all this information via email. So I'll pass it over to my colleague, Simi Geigel.
Good morning, everybody. Thank you so much for joining us today. Before we get started, I just want to mention a little bit about the CVOEO Microbusiness Development Program and microbusiness in general. Microbusiness is a statewide program that helps low to moderate income Vermonters start or expand a business. There's no cost for our services. Folks do need to confirm their eligibility for our services. So there's three counselors in the program, myself, Simeon Geigel, John Gergley, and Pacific Sangayuban. You can see our contact information on the screen in front of you. If you have any questions about our program or would like to learn if you qualify, don't hesitate to reach out to us. Next slide. I mentioned that microbusiness is a statewide program. There's a total of 5 microbusinesses around the state, and each microbusiness falls under what's called a community action agency. And each microbusiness covers a certain set of territories. We have Brock, which covers Bennington, Rutland. Capstone covers Washington, Lamoille, East and West Orange counties. CVOEO, Addison, Chittenden, Franklin, Grand Isle. NECA up in the Northeast Kingdom covers Caledonia, Essex, and Orleans. And SEVCA in the southern part of the state covers Windham and Windsor counties. And you can also see our statewide website below, mbdp.org, if you would like to connect with a specific program or with a specific counselor that serves your area. You can find that information there. Next slide. I do like to let folks know that there's other business support services in our area. We have Burlington's Business and Workforce Development Department, which focuses on Burlington, Center for Women in Enterprise, Mercy Connections Women's Small Business Program, the Vermont Small Business Development Center, SBDC. The Small Business Administration is a federal program, but you can find them online. And of course, finally, we've got Champlain Valley SCORE, Service Corps of Retired Executives in our area as well. So finally, I'd like to welcome today Nicole Colorin, Professor of Law and Director of Vermont Law School Entrepreneurial Legal Lab, Carrie Lebrecq, and Callum LaFrance. I'm not sure Callum.
Sorry, this actually, I apologize. I didn't change the names on this
slide.
Okay. Sorry,
That's okay.
Guys.
That's all right.
I am here. It will be me, but I'm going to be in the background. It will be primarily Professor Jeanette Ikes, Jeannie Ikes, and then our student today is Jasmine Shaw. Sorry about that, guys.
That's okay. That's okay. Thank you so much. I'm really interested in this particular topic. I know it's a topic that comes up a lot with folks, and when it comes to hiring their first employee, there's always a lot of question marks about that. So I know that you'll dispel some of the myths and provide us with some very practical information. So thank you and welcome.
And I don't know, Nicole, do you want, before we jump in here, to share some information about VSEL and what we offer?
Sure. So before we get into the meat here, so I direct the Entrepreneurial Legal Lab at Vermont Law and Graduate School. We provide access to legal services for small business owners in Vermont. And we do that through a couple of different services. We provide education to small business owners, so either through public presentations like this, or we can do one-on-one individual educational consults to answer legal questions. We also have a referral system through the Vermont Bar Association, who's our community partner. They have a panel of low bono attorneys who get paid a reduced rate to take referrals for small business owners. And our program covers up to 10 hours of legal services that's provided to each small business owner that's referred there. So those are the services that we offer, but we love to partner with our community folks, and CVOEO is one of them. So this is through a previous partnership through the Community Navigator Partner pilot project.
And I grabbed the share back from you, Nicole, because I don't know what the formatting did.
Oh, yeah, that was me. Sorry about that.
No worries.
I changed. It should be fine after this.
There we go.
I can't see your screen, Professor Ikes. Are you
Share
screen?
slide is loading.
Okay, because my screen is like frozen. And I don't know if I should log out and come back in really quickly. But
No, it's not you.
Do
It's,
you want me to take down the share, Professor Ike, so you can load it?
yeah, why don't you take down your share and let's see
There
what
we
it
go.
does.
There we go.
Alrighty. Let's try this. All right, without further ado, Jasmine.
Hi, everybody. My name is Jasmine Shaw. As previously mentioned, I am a Vermont Law and Graduate School student. I am in the Entrepreneurship Legal Laboratory, and today I'm going to be presenting on hiring your first employee. Exciting if this is your first time hiring an employee, or if you've had employees, currently have employees, just some tips. This is going to be a very broad overview for businesses and things that they should consider when hiring employees. So we're going to start at the very initial stage, which you'd say like in recruiting. So your entire recruiting cycle, this is going to be pre-hiring, pre-onboarding, and then we're going to go all the way down to documentation. So these are some of the topics that I'm going to cover: help wanted, employment forms, employee status, benefits, Fair Labor Standards Act, safety regulations, discrimination, retaliation laws, record management, and documenting. Next slide.
Hold on a second. I don't know why this is slow, but it was slow responding. There we go.
Okay, so a business is on the market. They want to hire an employee. And what are some of the things that they need to do? So first, you always are going to need, businesses need to post job advertisements, whether that's through Indeed, LinkedIn. I know sometimes people use Craigslist. There's Facebook Market now that you can also solicit candidate referrals. And then there's a plethora of other platforms. Also,
Front Porch Forum in Vermont is a frequent way we see advertising handled.
say that again.
Front Porch Forum.
Front Porch. Okay. Never heard of it, but another good source, it sounds like, platform to be able to solicit job applications. Also going to talk about business applications, a little bit of the interview process, job descriptions, and new hire onboarding. Next slide. All right. So you're hiring. What are you going to do with your job advertisements? And when I say what are you, I meant businesses at large. What are businesses at large doing? It is so vital and important that businesses provide realistic and accurate job descriptions. What do I mean by that? If a business, and this is pretty like boilerplate language on a lot of job descriptions, they will say, a potential employee needs to be able to lift 100 pounds. If your job actually has no such requirement, the job description, no one is ever going to need to lift 100 pounds. That's not a very realistic job requirement or job description. And it's something that should really just be left off. In the same vein, I would say if you have that this person will report to somebody in a different department and it's only you, take that out. That is something to not also include in your job advertisements, as well as your job descriptions that you would give to a potential employee once they're hired. Because what that does is it causes great confusion, and a potential employee is also not as they are also looking at you at your business and saying, do I want to work for this person? Why do I want to work for this person? And you want to eliminate, businesses want to eliminate any sort of confusion from the very beginning. And vice versa, a business expects that its employees are giving accurate information. And so in that same vein, you want to make sure that accurate information is being flows from job descriptions, as well as the employee also understands what are their realistic expectations so that they can have the opportunity to make the best decision for themselves. Also, on applications, in the state of Vermont and several other states, there is a ban the box. A business can no longer ask about criminal history on a job application. The caveat to that is a business can inquire about criminal history during the interview process. They can ask questions during the interview process. Also, on an application, applications can no longer ask for previous salary history. And that is because there was a lot of discrimination that was going on. People would move from one state to another. I mean, I could give myself as an example. I moved from Florida to Washington, D.C. That is such a great salary band. And using my Florida pay to then justify D.C. pay was disproportionate, was largely disproportionate. The cost of living in D.C. is like 3 times the cost of living in Florida. And so there was a lot of litigation around that. And so they have, federal laws have now come out and said, you know what, we're banning the salary box, I'm sorry, do not include this on any of your application materials. So please go through any of your application materials and make sure that you do not have any requesting prior criminal history or prior salary history.
So Jasmine, can you suggest here how to get information about salary from a potential employee?
Yes. So a way to solicit that information would be during the interview process. And it would be something as simple as, I'm going to use Professor Ikes. Professor Ikes, what can you give me a salary range of what you're expecting, or what are your expectations for a salary? And so she would then respond, I'm just going to throw out an arbitrary number, $90,000. And that gives an employer the information they need to say, this is within our salary band or what we're willing to pay or not. Similar to that too, as far as criminal history, you can ask within an interview if a person has had any prior, and you want to be delicate about how you present it, but you want to say, have you had any prior, we're going to do a background check. Is there anything that may come up on the background check? And then what that does is it opens the door for the employee to then give the details about that information. And again, similar to the ban the box and the ban on the salary, prior employees had faced a lot of hardship because they were unable to, in some certain cases where they had criminal history, to be able to explain their side of what took place. And it was very just black and white, some of these criminal charges. And so it was discriminatory in essence. And so by allowing the employee, when you're asking, we're going to do a background check, is there anything that is going to come up that we should know, that gives a potential employee the opportunity to then almost share a little bit of their story that's obviously you're not going to get when just pulling a report off of from your background check. Also, other questions to avoid asking, a business cannot ask during an interview any questions about marital status, religion, age, if a potential employee has children, any medical history, graduation dates. None of this information can be solicited during the interview from a potential employee. And to just reiterate, I want to say one last time about the job description. When a business is making an offer and they are sending out an offer letter, it is imperative that the job description that they've sent out to the employee, again, is very accurate and it's realistic about who they're going to be reporting to, what their job duties are going to entail. If a business feels like maybe there's you want to throw in a catch-all, a business can also always say and any additional duties as assigned by, but within the parameters or the scope of, if it's a secretarial position, within the scope of the secretarial duties. Any questions so far? I know there's just a couple of people.
On the slide, you noted that people shouldn't write on the resume or application.
Yeah, thank you.
What is that about?
Thank you for that. Yes, do not write on, businesses cannot write on the resume or applications. Writing on the resume or applications, if a potential employee that you interviewed ever wanted to come back and say they were discriminating against me, I didn't get this job because I was a woman, I didn't get this job because I was tall, I didn't get this job because, I'm over 40, they can use these documents in court to support anything that an employer has written on applications in a case and it can be used against them. So refrain from using any writing on applications, writing on resumes. What a person can do is you can have a business can have a separate evaluation form where where a business maybe lists the questions that they want to ask a potential employee. And next to it, they're grading them. There's like a scaled grading, like, did this person have this skill? Did they describe it? A business can keep separate notes, but do not write those notes on the resume or the application during an interview.
Just to give you an example, I had a supervisor at one point, and he was teaching me how to interview people, and he quote taught me how to look at their date of graduation and make decisions about their age. And of course that's discriminatory, and you shouldn't do that. And he would circle that date on the resume. And that's a bad choice. So things not to do.
Correct. Next slide. All right. Onboarding. You've got your employee, you're ready to roll. We want to get them onboarded. I do want to say out at the outset, for businesses, it's so imperative when you're going through hiring, and the amount of time that it takes to onboard new employees. It is such a huge financial burden to train someone, get a person acclimated with the culture, to give them access to telephones and key fobs, and then time if you have other employees who are also providing them training. When you start to quantify that, it can come to large amounts of money. So making sure your onboarding is very sufficient and very detailed, and also that it's a collaborative process. Not only is the business just getting information, but they also want to be soliciting back information from this new employee that they've hired to make sure that this person is the right fit for the company, and to actually make sure that this person, perhaps longevity, wants to be there for a while. So your offer letter. Vermont, like many other states, is an at-will state. At will simply just means that an employer is able to terminate the employee for any reason, as long as it is not based on the employee being a part of a protected class. What is a protected class? Professor Ikes just gave a really good example about age discrimination, based on sex, gender orientation, based on religion, based on, and I want to say too, with age, it's not just age discrimination on people who are over the age of 40. The law does cover that, but there's also a separate law that you can discriminate of someone based on age because they're not old enough, or, because that can be then interpreted that they're not mature enough, they don't have the skills for the job, they don't have the training for the job. So it definitely goes both ways when you are within. Go ahead.
And this is one of the tricky things. Age is really hard. So for example, a business may have great reasons to go out and, support their community and say, new graduates welcome. But when you say things like that, it can also be perceived as a problem, right? And discriminatory. So you have to watch even in your descriptions what you put out there.
That is correct. That is correct.
Simon, you raised your hand here.
Yes, hi. Just a quick question. What is the youngest age somebody can be hired at?
It's a great question.
That is a good question. And I'm going to do a quick Google search because I did not get that information for Vermont. I do know that for other states. If anyone knows.
I didn't mean to throw you a curveball, but
it's okay. It's
a great question.
It is a good question, and it should only take like 2 seconds.
And
I think oh, go ahead. It's kind of what I thought, but I just wanted to double check before I actually said this on the recording.
Yeah, sure. Go ahead, Jasmine.
So children under the age of 14 are generally prohibited from performing any non-agricultural work. There are separate requirements when there's agricultural work, kids working with their family on the farms. There are separate exemptions for that kids can be younger than the age of 14 if their family owns a farm, it's a business, and they're working on the farm as well.
Okay. So, so just to clarify, so over 14 in most instances, then if it's not agricultural related.
That's correct. Over 14.
Okay.
Jasmine, is there a between 14 and 16, is there some kind of work permit that they have to get?
Work permit. This is really in it. I don't think. Hold on. Let me go to my same link I just had. And I will tell you.
For some reason, I had it in the back of my mind that I thought 16 was the minimum age, but maybe not.
Okay, so here it says, this is on the Department of Labor's website, time and hour restrictions. So 14 and 15-year-old minors may not be employed. It says before 7 a.m. or after 7 p.m. This changes between June 1st and Labor Day. During school hours, they cannot be employed. Also, there's some additional restrictions. So they cannot be employed more than 3 hours per day on school days. On non-school days, they cannot be employed, and I say employed as in working, more than 8 hours a day. This equates to no more than 18 hours per week on school weeks. And so during the summer, when there's no school, they can work no more than 40 hours a week. And this is specifically for 14 and 15-year-olds. Now, let me see what it says for 16.
And there is a good child labor law poster for
There
Vermont.
it is. Yeah. Hold on, I want to see what it says for 16. So 16-year-olds are actually, it's the same. It's the exact same. So 14, 15, 16, and 17 have all the same restrictions.
That's good to know. Just another question when it comes to the background check and authorization. Can you pull a credit report on an employee, on a prospective employee?
You cannot, in the state of Vermont, you cannot pull a credit report. So during background checks, an agency that and a business is using, if they're using an agency, they could also be doing it themselves. But you are not allowed in the state of Vermont to pull a credit check. The things that you can pull is education, prior employment, criminal history, and driving record. No credit history.
Thanks.
You're welcome. So I'll talk a little bit about the forms. So forms that businesses need to gather from their new hire. One of the first forms is going to be your employee eligibility verification. That's a form I-9. Within the form I-9, the employee has to fill this form out themselves. If, say, for instance, they are non-English speaking or they need someone to translate, there is a box on the I-9 form that actually says, if you were not the person to prepare this, who helped prepare, make sure that that section is included and is properly filled out if the person themselves who a business has hired did not fill the form out for themselves. Also, a business cannot tell an employee what type of verification, identification that they can supply. On the I-9 form, there are 3 different categories, and each category has specific list of identification that a employee can give to verify that they say who they are. Some of that can be a passport, it can be a driver's license, your social security card, and each one must fall into either 2 of the categories, which is A and B, or C. C is specifically for passports, and if someone gives their passport, you do not need to gather information under A and B. I see a question in the chat. I'm going to read it out loud if that's okay, Dana. It says, I'm currently onboarding a new employee who disclosed during her interview that she is pregnant. I didn't ask, but she shared in the context of wanting to understand how we would support her during her leave. She didn't share how far along she is into her pregnancy or when she plans to go on leave. For our planning purposes, can I, as the business owner, ask her her timeline for going on leave? She has formally accepted the position. Has she formally accepted and started, or do you just have a formally accepted offer letter, Dana?
She hasn't started yet. She starts in a couple of weeks. We do have a start date planned already. But yes, she has signed the offer letter.
Okay. I would say talk to an attorney, because she's revealed that she's pregnant, and this is going to be very delicate information. Again, how we talked about like retaliation. You don't want a person to then say they knew I was pregnant and then they didn't accommodate me. You really want to talk to an attorney. And as Professor Kaloran stated, we can help find an attorney, but that is definitely a question I would ask for them specifically. Similar businesses, though, would typically wait until the person has actually been onboarded and started and then ask about the accommodations that they're going to need, because, obviously a person's going to need to request off time. But right now, if she physically, there's always still a time, even though someone has accepted an offer letter, that doesn't mean that they're going to start working, right? This could still be contingent upon background checks coming in, credit history, or they could just simply get another offer. And I've seen that several times. People will accept an offer and then they'll rescind their offer because they got a better offer to go across the street. You're welcome. Federal tax W-4 forms. These are the standard tax where an employee will just say, these are the amount of the deductions I'm taking. Also, employees need to fill out the state tax withholding specific to Vermont. If your business offers direct deposit, this is a good time to secure direct deposit information. Employee handbook acknowledgement. Businesses are up in the air with employee handbooks. Some businesses that are typically a business owner and one employee, it may be unnecessary to have a employee handbook. That's at a business discretion. Other larger businesses may have employee handbooks as a means to keeping their policies and their procedures outlined in it. The only thing to be aware of, though, is if a business has an employee handbook, anything that they put in the employee handbook may be construed and could be then held in court that the business said that they were going to do bake apples every day. I know this is a typical crazy example, and the business didn't. And so don't ever put anything in your employee handbook that is not an actual policy or procedure that the company upholds and is doing.
You really have to walk whatever the talk in your handbook is. If you don't do it, it can be held against you. I mean, that's the real key. The other piece I'd add to what Jasmine was saying is, I know there are some professions like childcare in the state of Vermont that require an employee handbook. So make sure that there's no regulation that forces compliance with that in your particular industry.
Correct. And then lastly, as always, please, please, please get an emergency contact. I can't tell you how many times people think like, oh, I don't ever need to give my employee my emergency contact information. And then there's an emergency and a business doesn't even know who to call on an employee's behalf and say, this employee's at the hospital or this happened. So please secure and get this information first day that they come in. Also, I want to make note, the employee I-9 form must be filled out within 72 hours of the employee starting. They need to, when they provide their identification, the business needs to make a copy of that identification and keep that identification with the employee I-9 form. The employee cannot provide a copy, let's say, of their driver's license or their passport. The business needs to actually personally see the driver's license or the passport or the social security card or whatever means of identification that the person is giving in conjunction with the I-9 form. But it's always advantageous to make sure you have a copy, date date your copy with, this is the day I received this employee I-9 form. And again, that form needs to be completed within 72 hours. Simeon.
I would add one suggestion to that. I've seen a lot of businesses starting to take a picture of the ID in the I-9 certification process to prove that it is not just a copy, right? So you never want to be in a situation where somebody says you didn't have the original when you were looking at it for the I-9. And then Simon has his, I'm sorry, not Simon, Simeon has his hand
That's
raised.
okay. That's okay, no problem. Just a quick question as it relates to the employee handbook. Is there a reason, is there a reason why a business should have it, meaning like it's detrimental to the business not to have an employee handbook for a particular reason?
Well, if the regulations tell you you have to have one,
Yep.
that would be detrimental not to have it.
Okay.
You have
Yep.
to by law. And then I'll let Jasmine jump in.
That was exactly where I was going to go, because that was a great example that she brought up. So if the regulation's required, you have to have it.
Okay. Does it work against a business? Let's say, even if they're not in a regulated industry, does it work against a business not to have one?
Oh,
Go ahead, Jasmine.
you can go ahead, Professor Ikes, if you want.
I was gonna say, you know, for small businesses, the real challenge, and since we're dealing with micro here, I would say that we're on the side of handbooks can be more problematic than they are helpful. When you're dealing with one or two employees and it becomes informal in the workplace, which it often does in a mom and pop shop, we end up with a lot of evidence against the employer. They said they'd do this and they didn't. They said I would get a review every 6 months and I didn't get one. And that often happens when you get that family vibe in the business, right? Those employee handbooks aren't followed. So the lawyers that I have spoken to about this in Vermont and the ones that have presented at the law school have generally come down on the side of, you know, if you've got 3 or fewer employees, don't have a handbook, because it's just more trouble than it's worth, unless you're required to by law. In the case of more employees, Jasmine, you worked in larger settings, you know, what are the values and why do you have an employee handbook?
So I think the employee handbook in larger settings, one, it holds the business accountable. And so they kind of can also use that as a strategic plan. And so when it's in conjunction with a strategic plan, the business themselves is also, their handbook is holding them accountable. Their handbook is also holding their employees accountable. Number 2, it creates accountability and consistency across the board. So an employee, and this is if the business is actually applying this consistently to each employee, but typically if they're doing this, they can say, these are our policies and our procedures outlined in our handbook, and we've enforced these policies. Not only, it's not arbitrarily being enforced upon this person, we've also done this in other similar circumstances. And so it can be used again if they ever came to litigation and said, hey, these are our policies, we've enforced these policies, with several other different people. So it kind of breaks down that barrier of this is arbitrary, or some of the retaliation claims like they treated me unfairly. They can say a business has a history then of showing, no, actually, our handbook holds up. This is what we've been doing. So it's great for holding them accountable. It's great for holding the employees accountable. It's a great strategic management tool too. They, at their annual meetings, they can go and say, hey, what policies are working, what policies aren't, based on feedback that they've even heard from their employees. Like some policies might just be too stringent. And the employees are like, this policy, and I might say like, everyone has to come into work at 8:30. That policy might be too hard on people who, again, coming from large cities, when you work an hour out, 8 o'clock might be a little unrealistic for them. Perhaps they can make it at 9. So having maybe that policy saying we can be a little bit more flexible, and the business recognizes this in their strategic plan, this is a great way then to update the employee handbook. Next slide. You're welcome. Next slide. All right, the fun stuff. And I say that jokingly. The fun stuff of managing the employee. Managing employees it has its good and its bad days. And so as businesses, be prepared. Your employees, everyone is going to have different personalities. They are going to have different expectations. So it's great to get their expectations. Everyone's going to have different work styles. So it's good to highlight their work styles. Everyone is going to need to be managed differently. But how you can draw some kind of consistency in those areas is performance reviews. Again, I want to just tie this back to the employee handbook. If the employee handbook says that a business is going to perform employee reviews at 90 days and then annually, a business needs to make sure that they do that. But even if a person doesn't have this, a business doesn't have this in their employee handbook or have a handbook altogether, it is very important to have performance reviews, especially if it comes to any sort of termination on behalf of the business, or if an employee eventually quits and then they again bring a claim. You always want to be covered, and the performance review is a way to make sure your business is covered. So performance review. Oh, go ahead.
I want to jump in and add something here.
Mhm.
It's really important to have that annual review so you don't create a bad environment in the workplace. Otherwise, folks will think they're only called into the office for a discussion about their performance when something bad is happening.
Mhm.
And you want to allow it to happen, to be normalized in the culture of the workplace. If it's not, it becomes very stressful and very difficult for employees.
That is correct. Thank you for that, Professor Ikes. So that's very true. Having them at 90 days is great. Annually is also great. And then what to do if you have an employee who's struggling. You've maybe attempted to talk to them at your 90-day, you've had another discussion at your annual review, and the employee doesn't seem to be improving. The next step is going to be a performance improvement plan. So you're going to document, as you've been documenting the 90 days in your annual review, you're going to document the times that you have discussed with the employee. I also would recommend, when I was working in HR, to have managers try to get the employee to sign the performance improvement plan. This can go one of two ways. Typically, people are willing to sign it. And that way, again, this is documentation that's down the road to keep you covered if this ever goes to litigation. And on my documentation point, I want to go back so I make sure I'm paying attention to my slide. Documentation can hurt or help you. The at-will statement, right? At will, we can release an employee for any reason at any time. This definitely implies that you actually have to have a reason. Instead, you want to use the wording or verbiage, something similar. We can release an employee for any reason or no reason at all. That is the clause that a business would want to put in their at-will policy at any time. And then lastly, make it an interactive process. And Professor Ikes actually just definitely kind of foreshadowed this statement here is, don't just bring employees in simply because, they're having a performance issue. A business always wants to create a hopefully non-toxic work environment. And by bringing employees in at 90 days and basically testing their temperature, asking them questions about what they like and what they don't like, and being able to gauge that, it makes that process interactive. Performance reviews can also include, just like annual reviews, where does the employee maybe want to grow? Maybe they want to move into another department. And so you find out during that time that they maybe want to try and acquire certain skills that will allow them to transfer over to another department. So the performance reviews are not always just centered solely around the employee's performance. You can also gauge and make this an interactive process by asking them questions about how they feel about the position. Do they have any future plans within the business or skills that they would love to learn? Simeon.
Yeah, just a question and maybe just a clarification on the performance review. So my question is really coming from the perspective that we work with micro businesses, and that's usually maybe somebody who's just hiring their first employee. So just to clarify, a performance review isn't required by the Department of Labor, but it is a generally accepted business practice that is good to do for all the reasons you stated. Is that correct?
That is correct. So performance reviews are not federally mandated. There's no law that says a business has to hold performance reviews. Performance reviews are a good tool for protecting your business in the event of litigation. It's also not just protecting your business against litigation, it's also a good tool to really, if you're just starting out as a business, to see what works and what doesn't work. This can, at times, I think if you're in a small business, like you're saying micro, it's maybe a little bit more informal. It's not, hey, come into my office, this is a formal performance review, but having formal performance reviews is advantageous.
It also can impact when you let someone go, your unemployment insurance rate. If you have done performance reviews, if you have managed your expectations with an employee and documented that, it won't cause as much of a spike in your unemployment insurance through the state, and the rate will be addressed towards someone who's managing their employees well versus someone who's hiring and firing sort of willy-nilly.
I see. Okay, those are both very helpful and practical. As far as the performance reviews go, and maybe you'll speak to this later, Jasmine, but are there resources that somebody that's hiring their first employee where they could go to kind of get these kinds of reviews? Is that something that's potentially offered through the Vermont Law School legal assistance?
I would recommend going to the Society of Human Resources page. This is a network of employees who work in human resources. However, I know that there is a fee to access their website all the time. If not that, Professor Kaloran, do we have any resource at school? I know we do have, there are books, but is there anything specific on performance reviews?
Not that I know of that's specific to performance reviews, but I want to mention here, because it's a good spot to do it, that we do have through the library at the law school, we have the Community Legal Information Center, CLIC. And that is a center where folks, if they want to, they can physically go down to the VLGS campus and they can do legal research with some of the paid services that we have access to on campus. They can do an interlibrary loan for books that they can have sent to their local library if they wanted to check some of those out. I don't know that we have any material specifically on performance reviews, but I'd imagine we have some HR specific law books that are available on the loan program.
And just to double down on the fact that performance reviews aren't required by law, so this isn't necessarily a legal problem.
Mm-hmm.
This in part is a management issue.
Mm-hmm.
And I would even look to, if CVOEO has some of those resources. If they don't, perhaps the SBDC has some support in this area. In fact, I know the SBDC has some support in this area around HR issues.
Yes. And I just want to caution too, because I do know that there's a plethora of information, right? Just simply by Googling. Don't always use boilerplate information, because it might not even be applicable to the job responsibilities or duties of the employee that you're discussing. So it's so imperative to make sure the questions that are being asked during the performance review are actually in reflection of the job that the employee is doing. And so that can be, if you're just downloading something off the internet, you'll realize like, this actually has nothing. I'm trying to interview a potential farmer, and this is talking about someone teaching students, right? It's like, so you actually want to make sure it applies to the job.
Thank you.
Welcome. Next slide. Okay, so you have your employee and you're either going to hire them full-time, part-time, perhaps seasonal, or this is an independent contractor. In the state of Vermont, full-time employees work 40 hours a week. Part-time employees work fewer than 30 hours a week. Seasonal employees work 20 weeks in a calendar year. So maximum is 20 weeks. that they can work. And this is for a seasonal period. And then an independent contractor. Just to be clear, an independent contractor is not an employee of the business. An independent contractor is a person that a business hires that perhaps has a specific skill that maybe someone in the job doesn't have, and they are specifically working on items that they're doing so independently. And I actually will just go down into the test. So in Vermont, the Vermont has an ABC test. A is control and direction. So an independent contractor, how the state of Vermont is going to assess is this person really an independent contractor, or are they more of an employee? Based on, do they have control and direction over their job duties, job responsibilities? Next, is this outside the usual course of business or outside the usual place of business? So this means outside the usual course of business, as I said, going back to my prior statement, perhaps this independent contractor is performing a very specific skill that no one else within the business has. And then
can I provide an example real quick here, because this is a bit theoretical.
Okay.
So let's say you're a retail company and what you really want is to post signs in your local community about your new retail location. You might hire a graphic designer to create those signs, right? And when you hire that person for that specific task of coming into your business, looking around, maybe take a couple pictures, put them on the sign, and do specific work in a specific way, that can be an independent contractor.
That is correct. So and this individual doesn't work, an independent contractor too, typically does not work with any of the employees within the business. They do all of their work at a separate facility. And then C is customarily engaged in independent trade. So individuals, examples like an individual has the independent contractor could be like, let's say tech. I know tech is a big, people hire independent contractors to handle their website or their intranet sites. And so this company Apple is providing tech for company Yeti, which makes bottles. And by doing that, they have their own employees. So just to kind of show you what it means, like they're customer engaged and independent trade, meaning Apple has its own set of employees that they're managing that are just providing services for a company, perhaps called Yeti, if that makes sense. And then the IRS has a very different test, not too different, but it's less inclusive to determine if an individual is an employee or an independent contractor. For the IRS form, I definitely recommend speaking more in depth with an attorney about, and they will get into the specifics about what's required under the IRS form versus the Vermont form. But in Vermont, you're going to, an employer must follow the Vermont ABC test.
Let me offer the reasons why this is important. If you hire someone as an independent contractor and they were really an employee, there are a lot of penalties that can incur to you as a business. You can have to pay back taxes and all kinds of other things on that employee. So be very careful that your independent contractor is really an independent contractor. You don't want to make a mistake here. It can be a very expensive mistake.
Correct. And I was actually going to add to that, if a claim was brought against you, they could get into your book of business and say, this person wasn't a salaried employee, they were a non-exempt employee, you owe them overtime. So as Professor Ikes just said, it might be you owe them benefits and you never paid them benefits. And so, yes, it's very important to delineate between an employee and an independent contractor. I also want to touch on, what's my next slide? I don't know if I threw this on a slide, but I can. Oh, yep, it is. It is the next slide. Okay.
Oops.
One
Sorry
more back.
about that.
It's just still kind of under this employee status. Exempt or non-exempt employees. So when you're hiring an employee, first you're going to determine if they are part-time, full-time, seasonal, independent contractor. Next, you're going to determine their status. What this means is if they are exempt or non-exempt. And there's a couple reasons why. Exempt employees do not accrue or are not entitled to overtime. Overtime pay is 1.5 times the hourly rate. Exempt employees are salaried employees. So on an offer letter, it says they make $45,000 a year. That is the amount of money that they're going to make at the end of 52 weeks. It should be the $45,000 a year, not including if a business has bonuses or anything like that. How to determine if an employee is going to be an exempt employee versus non-exempt. So by default, everyone is going to be an exempt employee. However, you, based on their job duties, can make the determination that a party is exempt. Exempt meaning they're an administrative or professional role, some executive role, and I say executive role, C-suite employees, so chief technology officer, chief human resources officer, chief, executive officer. These are exempt employees. Another way to also determine that is, does the employee have discretion and independent judgment? Now, this can kind of get a little murky because a lot of employees do have the ability to have independent discretion and judgment, but the determining factor is, are they using their independent discretion and judgment too while managing other employees? So is there a managerial level to being an exempt employee? That is really the determination that a business wants to make between exempt and non-exempt. Not only are they maybe in an administrative capacity, but then are they also managing employees? That also means, do they have any sort of hiring, firing authority? Some even look at, I know in DC, if they did payroll or timesheets, and I know some small businesses, maybe they outsource this to a bookkeeper. But if you don't outsource these services to a bookkeeper, these are also other duties that can be used to determine that an employee is exempt or non-exempt. And so here's just an example because job titles are not enough. As you can see, the assistant store manager 1, the assistant store manager 2, they both have the title of manager. However, one is actually managing in a sense of their hiring and their firing authority. They manage employees, they process leave requests, they work on payroll, versus an assistant manager who's just essentially, their duties are, I'm stocking, custodial tasks. Within the second example, there are no managerial duties that a person is doing. So that person will be classified as a non-exempt employee. And to just reiterate, a non-exempt employee is an employee who is paid on an hourly basis. An exempt employee is a salaried employee who does not get overtime.
So, Jasmine, I've often heard of employers trying to call people exempt so they don't have to pay overtime. What are the risks in this, and what happens? And is it possible for a business that is sole proprietorship to have one employee and have that person be exempt, or are they sort of almost always non-exempt? And what does that look like in a really small business?
So to go to your first, I was going to answer your first question. So your first question said, what happens if an employer wants to have someone that's exempt and not exempt? That was the first question, right?
They would prefer to have an exempt employee because they don't want to pay overtime.
Because they don't want to pay overtime. Again, this could end in huge penalties, litigation costs, especially if an employee can prove and they file a claim against the EEOC, which we'll talk about later. That's a agency. Huge litigation penalties for not classifying a person as non-exempt. They will not only can be held to fines, but they will have to back pay a potential employee that they itemized as exempt, but was truly, when going through litigation, identifying what this employee's job responsibilities are, and they're more in alignment with a non-exempt employee, they're going to have to pay the salary, any overtime, let's say any benefits that a non-exempt employee perhaps was getting. To your second question, if this is a sole proprietorship and they have one employee, and this one employee is exempt,
Can they even be exempt in that situation?
they're not managing anyone. I'm going to say this is slippery. I didn't encounter anybody because, again, I was working at a really big business, but this is definitely going to be a slippery slope.
See a lawyer?
Yeah, see a lawyer, because I'm in my mind, I'm actually trying to think of situations that I think that this would work, but
If they own a share of the business or something, I would assume.
maybe, yeah, if they owned a share, if they were a partner, but at that point they're not
Mhm.
they're not an employee, depending
Correct.
on how the equity is, and so they're not even, their status isn't even employee if you own a share of the business, depending on how the equity is.
So this exempt versus non-exempt categorization, if you have a question, because of the penalties can be so high, speak to an attorney.
Yes, don't risk, especially small businesses. I'm not saying that big businesses, they should not do this either, but as a small business, don't risk it. The litigation costs can actually bankrupt businesses. Next slide. Employee benefits. So the next couple slides, I'm going to talk about health insurance, family medical leave, Vermont's family medical leave, workers' compensation, and unemployment. Health insurance. Okay. Does an employee or business owner in Vermont, do they have to pay health insurance? In the state of Vermont, a business that has more than 4 full-time employees, that means employees working 30 hours or more, must provide health insurance, or if not, they have to contribute a certain portion of their income, not the employee's income, but the business must pay into what is called the health care fund contribution. This is information that's on the Department of Department of Taxes, I think,
It's
website.
Department of Taxes.
Taxes, yeah, Department of Taxes.
Not where you'd expect it.
And I can drop a link with that information to go if you want to look more into it. But if you have 4 or more employees that are working more than 30 hours a week, a business must provide health insurance. And if not, they then must contribute to a health care fund contribution. Also,
it's with the form on the tax department, just to give you an idea where it's at. It's with the quarterly withholdings and quarterly payments to the Department of Taxes. So it's right there as one of those quarterly withholdings.
Correct. Also, I want to include businesses. You must report if a business is not actually providing health insurance. They must report that and this is just a business documentation thing, that they'll ask how many healthcare covered employees did you have. Even if you're contributing to this healthcare fund contribution, the employee will still be classified as an uncovered employee within the business. Or let's say that they're getting, they're on their spouse's insurance, so they're not covered through your business. That still means that they're an uncovered employee. Healthcare fund contribution expenses or fees are due and payable on or before the 25th of the calendar month of each quarter. Paid. Oh, yes, Simon.
Yeah, just a quick question and clarification with that last point. If somebody just has one employee, do they have to fill out that form you spoke about, indicating that they're not responsible for paying into it, or do they only fill it out when they are responsible?
You mean the healthcare fund contribution?
Right, yeah.
So the healthcare fund contribution is only for if you have 4 or more employees. So basically, an employer that doesn't have more than 4 employees doesn't have to provide healthcare benefits.
Right. Yeah, I guess I was just was confused if they had to still fill out the form basically stating that they're not responsible for that.
No, they
No,
do not.
okay.
But
No,
the,
no.
but the employee, and this is separate, don't confuse this.
Mhm.
An employee that chooses to be on a spouse's or has some other health insurance has a form that they have to submit to their employer.
I
And
see.
those are distinct.
Gotcha. Thank you.
The business is responsible for supplying that as well with the federal filing.
Thank you.
Correct. Paid sick leave. So all employers, no matter how big or small, 1 employee to 10,000 employees, must provide paid sick leave. Paid sick leave is employees must be permitted to accrue at least 5 paid sick leave days or 40 hours per year. And this is for all employees that are working more than 18 hours on average a week. So I kind of want to go through that again. So all employers, no one is exempt from paid sick leave. An employee who's working on average more than 18 hours a week, 2, must accrue paid sick leave. And that minimum, they have to be at minimum permitted to accrue at least 5 sick days or 40 hours per year. So there's kind of like a 3 requirement there. Also, at the end of the year, there are 3 different options a business can use because employees cannot, the state of Vermont, go ahead. Did somebody say something?
No,
Sorry.
I was sneezing.
Within the
Sorry.
state of Vermont, you cannot leave any basically unused paid sick leave must either be allowed to carry over so that the employer has the discretion to either allow an employee with unused paid sick leave, they can carry over their leave, they can cash it out at the end of the year, or provide a lump sum of leave at the beginning of the new annual period. So an employee with basically unused sick leave you can't just leave it as is. It must be either carried over, a business must either cash it out, or they must provide a lump sum. Those are the 3 things. COBRA. So back to our health insurance talk. COBRA. If you are a business and you are providing health insurance, if an employee either quits or is terminated, an employer must provide COBRA information. COBRA is essentially, it's temporary insurance, employer provided coverage, temporary insurance that an employee can have until they're able to find, let's say, another job where they're going to be getting benefits. This is applicable though for only businesses that have 20 or more employees, either in the prior year, in the prior year, and their families. That's not an and. I take that back. It's only this is only applicable to 20 or more employees for a business that has 20 or more employees, let me say it that way, in the prior year, must provide COBRA to any employees who are either they've terminated. It must be a qualifying event, but termination is typically the norm. And that termination could be either on the employee or the employer side, death, or let's say the business they just go out of business, they go bankrupt. An employer has 14 days to send out information once an employee has been terminated out of the system about the qualifying event that took place. And it's going to include information describing what the benefits are that are going to be covered, the new amounts that are going to cost if an employee wants to keep the same benefits that they had. And also there's an election period if a prior employee at this point has said, I don't want to extend my coverage. Family medical leave. So family medical leave is a federal law. And the state of Vermont also has their own federal medical leave as well. Federally, though, this applies to 50 or more employees, and also to private employers with fewer than 50 employees. Employees are eligible if they have worked at least 12 months or 1,250 hours, and the employee is located within, meaning where they live, where they reside, is within 75 miles of the work location, the facility. So actually where the work is. So if someone's in Burlington and they live in Montpelier, they are within the 75 miles. If the employer is located in Burlington and a person lives in Hanover, I don't know the math, but I think that might be greater than 75 miles. The Federal Medical Leave Act would not then apply to that employee. What is it? An employee is eligible for up to 12 weeks of unpaid leave for either the birth of a child, care for a newborn child, adoption that has taken place within 1 year, to care for their spouse, the child, or parent with a serious health condition. Perhaps the employee themselves has a serious health condition and they need to take family medical leave. If they are providing care to someone that's military that needs extensive care. And this leave does not have to be taken consecutively. So a person can say they can apply for family medical leave. They can take maybe 2 weeks now, and then 2 months later, maybe they need to take 3 weeks again. So the leave also does not have to be in succession. They can take it
Continuous.
when they need to. Go ahead, sorry.
Continuous. That was the word you were looking for.
There we go. Thank you. Yes. Also, this is important to note. Sometimes employers also have their own paid leave programs. And if a employer has a paid leave program, they can essentially use the paid leave program simultaneously with the FMLA, meaning they're going to receive pay from their job, and then FMLA, which is unpaid leave, but 12 weeks, it's kind of like one is on top of the other. Like they're still getting paid because the employer is providing paid leave, but they have up to 12 weeks that they can take unpaid leave, even though the employer has their own plan.
Can they separate that out, Jasmine? So could they, if the employer says we offer 12 weeks of paid leave, can they then take 12 weeks of unpaid leave?
Yes.
Okay.
Yep, that is possible. They do not have to take it simultaneously. So they can say, all right, let's say pregnancy, childbirth. And let's say I'm like, okay, I want to take my first 12 weeks paid, and I want to take maybe I don't even want to take another full 12 weeks, but maybe I then say I want to take 6 weeks unpaid. You can do that.
And it's the employee's choice, not the employer's.
Correct. The employee's choice, not the employer's. And again, this is only for like making sure that this employee has been with the company for 12 months. They've worked, at least the 1,250 hours, and they live within 75 miles. So if those 3 things aren't met, the person is not eligible for family medical leave. We can go ahead.
Does the state of Vermont have work is within so many miles requirement, or is it only the federal?
It's only the federal.
Okay.
Yep. If we want, in interest of time, I was gonna say we can go to the next slide. Workers' comp. Oh, Simeon.
Yeah, sorry. Just to clarify, so if it's a micro business placed with one employee, they're not obligated to provide the Family Medical Leave Act benefits. Is that correct?
Correct. So with the family medical leave, but let's say it's the state and they have at least 15 employees, and micro might also include 15 employees. So while it might not be federally mandated, a business that has 15 or more is basically obligated by the state and must follow the state's Family Medical Leave Act.
Okay, thank you.
You're welcome. Workers' comp. What to do if someone's injured on the job. Workers' comp, the rates are determined by the state. workers' comp insurance, a business will get insurance through a private insurer. And there are a couple levels of reporting. So first reporting is typically what a business wants to do. They want to report a injury as soon as possible. And they're required by law to actually report an injury. When you're reporting the injury, it can be something as essential as like medical attention. So say someone fell and twisted their ankle, or maybe a person fell, twisted their ankle, you didn't realize it, but then they say, I'm unable to come into work today because I fell and twisted my ankle late last night. An employer must report that immediately. First reports. I also want to include that because you are reporting as the employer, that doesn't mean that you're actually liable. It is just federally mandated that you need to report any injuries. And most of the time too, your insurer is also going to have certain conditions that must be met for your plan. Prompt reporting is, let's say you didn't, an employer didn't even realize that an employee got hurt until 3 days later. An employer must report that injury within 72 hours of notice. So if it's 2 weeks ago, or 2 weeks have passed, the employee says, man, I really hurt my back from lifting boxes 2 weeks ago. At that moment, the clock starts ticking under prompt reporting that you need to report that within 72 hours. So if it's Wednesday, Friday is the deadline.
So
then,
for the work location, Jasmine, does that have to be on the employer premises, or can you hurt yourself somewhere else while doing work for the employer and still have it be a workers' comp claim?
So no, if you are working as under the employee, so say for instance you are a plumber and you've gone out to a house and you get injured, you can still get workers' compensation because you were still working the duties of your job, fulfilling this job duty at another location. Now, this can kind of be slippery too in litigation. They're obviously going to look at, was this really still in continuation of their work duties and responsibilities? But mostly, to answer your question, if an employee is actually doing their job just at a different site, it can still be a workers' comp.
And so how does that impact our new post-COVID world?
With virtual working from
Yeah,
home.
and remote employment.
Okay, so remote employment is, well, as you know, since COVID is only 3 years behind us.
Exactly.
There's not a lot of litigation out on it yet. I do know prior to COVID, the amount of people who were working from home was, it was few compared to what it is now. And so this is still an area of growing litigation. And so this could change. I mean, there's not really precedent that a court is going to look to determine this. This is really, honestly, it's still new law. And this is something an employment attorney is going to have to work with you specifically on.
Absolutely. But I would say, just as a matter of doing business well, if you find out about an injury and you think there's reason to believe it could have occurred on the job, talk to your insurer, have a conversation, ask how they want the claim filed.
For sure. Unemployment insurance. Unemployment insurance. So one or more employees during some part of the day, meaning that they've worked at any point of the day, they worked at least with your business for 20 weeks. They're also getting, meaning the employee has gotten paid at least $1,500, not at least, but say they're salaried for $50,000 a year. That means that basically they're being paid greater than the $1,500 requirement. And there's slightly different requirements for 501c3s. So 501c3s must have at least 4 employees for 20 weeks. And I want to include too that the 20 weeks do not have to be consecutive. So say Billy works every other week. right? That's just the work arrangement that you have. That still means as long as it's been 20 weeks, that's still satisfying that 20-week requirement.
And 501c3 is a nonprofit corporation.
Yep, I was going to go into those. So there's religious, charitable, education, or any other organization that files this exemption status. But most people know them as religious organizations, charitable organizations, or education. Those are like your typical when you think of a 501c3. And then for agriculture, so this is interesting. I found this in the state of Vermont. In order for unemployment insurance, the employee who's no longer working was paid more than $20,000, or the employer employs 10 or more employees, including legal aliens, during some part of the day, even if that means 30 minutes a day. And this employee has worked more than 20 weeks. And again, these weeks do not have to be consecutive. They could have been every other week, bi-monthly or something like that. We can go to the next slide. Fair Labor Standards Act. I think most people are probably aware of this simply just by having a job and wondering what the Fair Labor Standards Act is about minimum wage, but is your business covered? So there's two types in an enterprise. So you at least have 2 employees and the volume of business is at least 500,000 or more. That's one way that you can be covered. Or there's individual coverage. Individual coverage means basically anyone, any employer, any business that works in interstate commerce. And these days, that's just about everything. I don't know too many businesses that don't work in interstate commerce. And when I mean interstate commerce, means like you're selling something to someone else across state lines, right? We are selling hats across state lines, or we're using the interstate to, and I use interstate as in, but this is just a means of commerce, right? We have employees going out because we have a plumbing company and we're providing services at home. So essentially, Florida Fair Labor Standards Act apply to just about everyone. I have not come across a business that did not qualify under this ever. I can't even think of an example. Can you, Professor Ikes, that someone who wouldn't be covered under this, who's not engaged in interstate commerce? I can't think
it's very, very hard to think of anything.
Yeah.
And it was intended that way. It was intended to be as comprehensive as possible.
Correct. Next slide. Yes, Simeon.
Maybe you'll get to this question with this next slide, but so just thinking about a very typical micro business, I'm thinking about a landscaper who has 1 employee and they just do jobs on people's residences and say in Chittenden County. Would they fall under this?
Mm-hmm.
Yeah. Okay.
Correct. It really is everybody. Like I can't think of one employer that does not fall under Fair Labor Standards Act that they have
and frankly, it's just not worth the litigation and the risk. Comply with this stuff. It would be very hard not to comply.
Correct. So Fair Labor Standards Act, there's 3 minimum requirements. Minimum wage for all hours worked, and this is non-exempt employees, as I explained earlier, because exempt employees are ineligible for overtime pay. So minimum hours worked, overtime pay is time and a half after 40 hours. So let's say that your business, your hours that your employees work is full-time 35 hours a week. From 35 to 40, your employee would still get their hourly rate. Once they hit 40 hours and above, they are paid time and a half. Also, FALSA requires record keeping, so timesheets. You must keep all of your information recorded showing what days your employees worked overtime, how much overtime was paid, how much they make an hour. This is just goes to documentation. This information must be kept on file. Now, Vermont has their federal minimum wage standards, and Vermont's for non-tipped employees, it is $13.18 an hour. And January 1, 2024, it's going to increase till $13.67. And then for non-tip or for tipped employees, so those who are typical, you think servers, currently their minimum wage is $6.59, but it's also going to see an increase January 1 of 2024 to $6.84. Next slide. OSHA. So there's quite a bit of information on these slides, so I won't read off everything, but I want to just let everyone know all businesses must comply with OSHA regulations. This is federally mandated. If a business does not comply and an employee, and they find violations or an employee, what they call whistleblows about non-compliance, again, serious litigation. But what OSHA is OSHA basically says a workplace must be free from serious hazards. So depending on the industry, depending on what your specific business is, if you actually go on to OSHA's website, they have specific industry standards that outline what procedures and protocols a business must adhere to. And we can send this slide too, because some of these you can actually click on. They're hyperlinks on the slide. Next slide. Workers' rights. These are, it's essential for your workers to know their rights. So this is just essentially for the workers, how they can file violations if they brought something up to the employer and the employer is still has not repaired, maybe let's say some serious hazard. An employee has the right to make a claim to OSHA, and also this by making this claim, a business cannot then come and retaliate against the employee. And
So
also
a common example in Vermont is if there is a place where water pools and tends to freeze and creates a slipping hazard on the premises, right? You have to fix that. You can't just leave it that way. So those hazards that are in the workplace where people walk back and forth all the time, and there's a risk of falling because of the way the floor is. You've got all kinds of risks and other things like that are covered under OSHA. Do you have another example, Jasmine, of a workplace hazard?
Yeah, factories are a big one. So when you have factories and they're working with heavy machinery, and let's say that there's some factories where there are doors that before you go into another room that you have to be in certain gear. Once you go into the factory, certain levers, any type of buttons, they can't be within certain distance and at a certain height, because, for instance, an employee could accidentally bump into it, and then that could cause serious danger or harm to maybe the person that's working on this specific machinery. So that's I think of serious hazards. This is big in any sort of factories, a lot of industrial farming, depending on how big the farm operation is. Think of Tyson's and places that are massive, and they have different areas of machinery going on. They have to comply with OSHA. They have to make sure that their employees wear certain colors too, so that no one, so that they know where their employees are at certain times. If protecting their employees against any sort of chemicals that come from working in these factories, that's also even for farm workers. I know that's a big thing too. Pesticides, that also falls under OSHA. But on to the next one. So Vermont also has their own OSHA. They enforce the federal OSHA, but OSHA is covered by, or those who are covered by it is private sector workers, and state-run health and safety programs must at least be effective as federal OSHA programs. So state-run health and safety programs, those might be federal programs, or they might just be a separate state entity that has their own health and safety programs that they're running, but they must be at least effective as the federal law. And then state and local.
In Vermont, you hear this referred to as VOSHA when business owners talk about it.
And then this is just extra information. State and local government workers are covered. Who is not covered within government workers, which was news to me. I didn't know this till I looked it up, but I did not know that USPS workers were not covered by OSHA. And then any person that is working with their immediate family on a farm, and the farm has 10 or less non-family members, are exempt. And then self-employed workers do not fall under VOSHA or OSHA. Next slide. Termination. Okay, this is not a happy day. Could be not. But what to do in the event that you have to terminate an employee. Have a witness in the room. This is, again, I want to let you know, this is all business advice. This is not legal advice. This is not federally mandated saying you have to have a witness in the room. You do not. But it's advantageous to have a witness in the room. Again, for anything of litigation, something could come back to you. It's better to say having another person who can identify and say, actually, I was in the room. That is not what has happened. A business does not have to say, I'm sorry. Don't say you're sorry. Be straight to the point. It's better to be honest. Keep it to the facts. State the actual reason why you're letting them go. But make sure you're also brief. So don't talk to someone for 30 minutes and just lay into them about all their many discretions. Don't do that. That is not an effective means of terminating an employee and how it could possibly make the employee feel. Make sure you terminate any electronic access. So for instance, if they have your business has provided computers or key fobs, if they have a cell phone that they've been using on behalf of the business, you want to terminate access at the moment you are talking to the employee. So if you're in a large enough business and you have a separate IT department, if you know that you're going to be letting Johnny go at Friday at 5, come 5 o'clock, all of their access should be terminated. Also, if this employee has any personal data from the business, maybe on devices, that information too needs to be destroyed.
Jasmine, is there a reason that when you hire someone, you should get them to agree to destroy that when they leave?
Yeah, so you have any sort of like copyright infringements. Let's say that this is
just data.
Like patents, just data. Yeah, it's just simple data, right? You don't want someone running with other people's data, with your
sales people tend to try to walk off with their sales list of leads.
Yep. Or if you're also just protecting IP, right? Like Apple might want to say, I don't want you taking all of our information to Google, which that could have other things, but that's also another reason why. Also, final paycheck must come. This is federal. Federal law says 72 hours. So if they are let go on Friday, by Tuesday, this is business days, Tuesday, they need to get their check. And then also, if your business is providing benefits, health benefits, COBRA will be triggered at a termination. Next slide. Discrimination and retaliatory laws. So we can kind of move through these quickly because I feel like they're really, a lot of them tie into each other. But Title VII and the Fair Employment Practices Agency, as I was stating at the very beginning, any discrimination on race, color, religion, national origin, sex, all of these things are protected class members. And so employees at times, if they feel as if they've been retaliated against, they can file claims and say, under Title VII, I was let go for my gender identity, perhaps. And this applies at all stages of the employment. So at any point in the employment, someone can, even if this wasn't a termination situation, but say they feel like they're being discriminated against because they weren't eligible for a bonus at the end of the year, or they didn't get the promotion that they were seeking. And they're saying, I've been looked over for promotions for the last 5 years based on my gender identity. And then sexual discrimination includes sexual harassment. Next slide. American Disabilities Act, this is the ADA. So this covers employers with 15 or more employees, and a disability includes physical or mental impairment that substantially limits one or more major life activities, or it can be a person has a record of such an impairment or is regarded as having an impairment. And so what this means is businesses must provide reasonable accommodations to employees who require an accommodation. What this doesn't mean is that an employer can have an extreme hardship in order to, let me get my words together. What this doesn't mean is that a business essentially doesn't have to have severe economic hardship by trying to provide an accommodation. So for instance, let's say, I'll just give an example from my past life. We had someone who was out for almost 2 years with a disability, and we were anticipating they were coming back several different times. We could not hold that position open for 2 years. And this is definitely applicable to small businesses too. A small business, while 2 years is a long time, a small business might be able to say, like, we're only 5 people. We can't afford for Jasmine to be out for a year, right? This is going to be a severe hardship to our company if, we're unable to meet her accommodation, right? And in this instance, the accommodation was the person needed to not be present at the job. But say the accommodation is they just need a lumbar support, right? A lumbar support is something that you can buy off of Amazon for like $20. That's not going to be an economic hardship on the company to provide a lumbar support for someone. Also look out for ADA claims too, and retaliation. Like I said, when you're hiring an employee and perhaps you physically recognize that they have a disability, and then they also share with you that they have a disability, that you aren't discriminating in your application process by saying, we can't hire them because, we don't want to make the necessary accommodations for this employee.
It's really key to know that you can be honest about economic hardships, but you really have to document that and demonstrate that it is truly an economic hardship.
Correct. And make it an interactive process too. So if you have people who need accommodations, definitely don't make them feel like, you don't want to make it seem like there's any sort of hint of discrimination. Ask them, be open. How can we help you do your job? What are some things that you need to do this job effectively? And then see what is a reasonable accommodation to be able to help them. And again, that ties into when it becomes unreasonable, it could be an economic hardship. The EEOC is just additional information on the slide, but that means just making changes at an existing facility accessible, perhaps job restructuring, also modifying or acquiring separate equipment. These are just what the EEOC says, but it's not limited to that. Next slide. ADEA, so the American Discrimination in Employment Act. You cannot discriminate federally. You cannot discriminate against a person 40 years or older. This happens, I won't say happens, but I'm pretty sure people 40 years or older, this is not a generalization, but perhaps aren't as tech savvy as everyone under, let's say, that's 16 years old. And if you are getting rid of an employee who's over 40 to then hire a younger person, that's age discrimination. An employer still must provide a reasonable accommodations to train this employee. Let's say, again, if they're struggling with technology, they're a little bit older, they didn't grow up with this. You still have to help train and provide the tools so that this person could become, right? They might not have to be 100% tech savvy, but they have a general knowledge of how to use certain applications on a system. In the inverse, this applies to discriminating against anyone who's younger than 40, right? This is through FEPA. FEPA says you cannot discriminate against someone younger than 40. So if you say, we want mature, if your job posting says we want mature individuals with 10 years of experience. And as Professor Ike said, perhaps this employer is like, okay, mature individuals with 10 years experience, they're getting rid of everyone who's 16 because they're like, well, surely you didn't have job experience at 6, right? At 10 years ago. So Just something to kind of keep in mind. Next slide. Employment posters. So businesses must place posters most people do it in their break room, but in an area where there's going to be wide access of your employees. This includes the A24 unemployment poster, accommodations for pregnant employees, child labor laws, crime victim, earned sick leave, healthcare whistleblower, OSHA, minimum wage laws, parental and family leave, safety records, sexual harassment, and worker compensation. All of these posters must be posted in a place of business, even if you have one employee. And there's also a link to these employment posters that anyone can look at. Next slide. Document, document, document. I'm sure many people have heard this several times, but this is something that is almost like Bible in the HR world. Document everything. Now, documentation can also hurt you, as we said, but you want to be making sure you're documenting things such as you've talked to somebody during your annual review, you talk to them again, you put them on a performance improvement plan, and you're documenting areas that they improved, they didn't improve. You provided training, you're documenting when you provided training. You're also following this. This is why documentation also can hurt you. Make sure you say, if you say, we're going to follow up with this person for training, and 6 months after we've talked to them about maybe a bad performance review, if you don't follow up with them in 6 months, that can be used in litigation. So make sure when you're documenting that you're actually going to do what you say.
If you document it, you better have done it.
You better have done it. Yeah. And some paperwork you're required to keep on file. So you're required to keep your applications and resumes on file for a couple of years. And then we already talked about the Vermont at will thing. And I saw someone's question. Give me 1 second.
It's a great question.
Yes, that is a good question. Yes, that's sufficient. And that's it. Any more questions? And thanks
Since
for
we're
bearing.
recording this, let's read that question out loud because it is a great question.
Yep. We had a question in the chat. It says, if my employees are remote, is it sufficient to keep digital versions of the posters in a folder in a shared drive? The answer is yes. Yes, definitely. Thank you everybody for listening to this, and
I'm going to stop sharing and give folks an opportunity to ask questions.
Absolutely. Any questions?
I want to encourage people to ask questions. I know I have some, but I'll defer to anybody else that has questions. Okay. I will, if any of my questions trigger other questions, please feel free to jump in, either unmute yourself or post them in the chat. I'm curious, I've heard talk in Vermont about kind of funding and paying for childcare. Is there any employer requirements around that at this time? And if not, might there be?
I don't believe so. However, I'm going to look this question up, and actually,
I actually just did some presentations around this. The way the payments are going is to the providers from the state at this point. There aren't employer requirements. Could there be in the future? Absolutely. There's a great movement to transform childcare and how it works in Vermont at the moment. So, you know, but it's the legislature. So predicting the legislature is, you know,
yes,
challenging.
I can hold you to that. Great, thank you. There was a form, and I'm blanking on the name of it. It was for people who were registered as an LLC, and they could fill it out so they did not have to carry workman's comp on themselves. Does this ring a bell? And if so, could you just speak to it briefly?
was this a sole member LLC?
I think it would have been, yeah.
Yeah, that meets the expectations. It could be that they just document it, but if you're the owner, you don't have to carry your own comp in that way.
Yeah, it was a form. I'm forgetting which department it came from, but
It's got to be Department of
Bit of
Labor.
labor. Sorry.
yeah, I thought so too, but something I thought it came from like some Department of Industry or something to that effect. But you're probably right. I'm sure it's Department of Labor. Um, are you familiar with that form and people electing to do that?
I'm not. I'm actually on here on the Department of Labor's site, as you said that, about claims and what they need to submit and or have insurance. I'm trying to look under their forms really quickly. I'm just trying to see what the forms say, but
The workman's comp is a process where you have to make your declarations anyway, because you have to classify each position.
Mm-hmm. Mm-hmm.
And based on the classifications for the position, that decides the insurance rate, right?
Mm-hmm.
So I would assume that you have classification as owner and non-owner in that. I vaguely recall filling that out myself at one point. So I think the way that's handled is by classification. But it could be that there is a form for sole owners that is
yeah,
separate.
I just found the form that I
found
completed.
it.
Yeah.
Go ahead,
I found
Dana.
it too.
Okay.
It says application. Is this the form, Dana? Application to exclude corporate officers or LLC members? This the same
Yeah.
form?
Yeah.
Yeah.
And
Okay.
it is that. It's basically if you are an officer or member, and then essentially you have no workers. So it's a sole member LLC.
Thank you. Thank you,
I
Dana.
don't have any employees. Please don't fine me for it.
I'm curious if you could speak to if there's any rules or for people that might use family members in their business. I'm thinking about family members that might have their children or other family members helping them in the business. Are there any nuances along the labor laws that relate to people that work in the business that's related to the owner, whether that's around workman's comp or other labor type of laws? I think you mentioned something around ag businesses, but beyond that.
Ag businesses is the only one that I'm aware of, and because that's typically what comes up in most of these documents. There's usually exceptions for like ag businesses. Go ahead, Dana. But I'm gonna look more. Dana has her hand up.
Oh, sorry. Yeah, it's unrelated to that question, but I was just wondering if there's a resource for where I can learn what I am and am not allowed to ask in an interview.
Yeah.
I'm laughing because it is so tricky, and you're dead on. There should be an app for that, right?
Yeah, I feel like I'm extremely cautious, and I'm new to the interviewing process in my business, but yeah, I would love some a resource that could help me understand that better.
I would definitely recommend SHRM again. HR, like the Society of Human Resources Management, they have a lot of do's and don'ts, but on a just general, any questions around like personal characteristics, right? So like when they've graduated or what religion they are, marital status, like those questions are totally you can't ask. You can't ask those questions.
And here's another tricky thing. Sometimes they volunteer something, and when they volunteer it, you have to be careful about how or what you do for follow-up.
Yeah. And I want to add to reference checks too. So that's also another gray area. I'm going to come back to you, Simeon. I'm still thinking about your question too. I'm actually Googling at the same time. But reference checks too, when you're doing reference checks, you have to be businesses have to be very careful about questions they ask prior employees. They must specifically be they have to be related to the skill, right? A business can't call and say, was Johnny late 5 times? Like that has nothing to do with the job duties. And I know that from what I've heard in Vermont, it's a little more congenial because it's smaller, people know each other. And so they may ask other questions, like, would you rehire this person? really those questions shouldn't even be asked. It's always supposed to be around the job and the job responsibilities and duties, and did they perform them effectively? But to your question, Simeon, I don't see other necessary industries that have, but I don't mind looking it up for you and sending you an email.
If you have an
Absolutely.
opportunity, if you have an opportunity, that's wonderful.
It'd be
Thank
good to know.
Yeah.
It would be good to know, and additionally, there's, it tends to flow out of the, if someone does work for you, you have to pay them
Mhm.
requirements. So my best guess is that even if they're a family member, if they're doing work for you, you have to pay them.
Mhm.
And if you have to pay them, then you have a comp
Mhm.
issue potentially, or
Right.
an obligation, so.
Yeah. That's
And
kind of my default too, but since I had you here, I thought I would ask and just try to confirm.
Yeah, and I want to say there's also, it behooves employers to pay their family members anyway, like tax when they're paying their children. There's also tax deductions that come out. You hear people who say my kids are on payroll because it behooves them for tax deduction. So I mean, that's a reason why a business would want to pay their family members who they're employing, especially when it comes to like children. But I will dig deeper into this for you and let you know.
Thank you.
You're welcome.
Yeah, just a kind of a little subset of a question that you mentioned at the tail end. So if you're a small business and your employee is using their phone and the kind of that's their personal phone, but there's still business being done on it and maybe information. I mean, how do you juggle that and separate their phone, which is their personal device, from business?
So Jasmine, I'm happy to address that since this is
Oh, go
kind
for
of
it.
in my areas of expertise. You have them sign a document that promises they will not use their device for business purposes
Okay.
while they're employed for you, with you. It's really the only way to manage this.
Mhm.
And it's messy, as you, I'm sure, know. If the employee has to rely on a mobile device for work purposes, you're better off supplying it so that you can take it back at the end of the employment.
Okay.
Employees hate that. They don't want to have to carry two mobile devices. But it really is the only way to have those guardrails necessary for ensuring that that data stays with the company.
Okay. And can
I was
you?
I was
Go
going to say,
ahead,
I've seen too, especially because nowadays everyone's got a cell phone and it's so easy to access and get information. I've seen in other instances where businesses will pay like a portion of their phone bill, but I lean more on the side of what Professor Ike say, that, having a separate phone is better than actually allowing them to use their personal phone, because it can get very murky.
I would tell you that the other thing from an IT perspective that's happening is businesses require access to your personal phone. And they can do it that way as well. My current institution that employs me had all kinds of security requirements, and I could not log into any of their applications unless those security requirements were in place on my phone. And they isolate that data and stop me from copying it in any way.
Okay. I'll throw two more questions out at you that's occurred to me. One, and they're unrelated, but one is, can you talk about having employees sign non-compete clauses, and also talk about Googling or researching a potential employee before hiring them, whether it's looking up their Facebook page or Googling them to see what comes up.
Yeah, so I'll do your latter first. And technically you shouldn't be Googling someone, because again, that can be discrimination. There have been cases recently litigated where businesses have gone on to Facebook sites and Instagram sites, and they've seen employees, I guess, exhibiting behavior that they would not
Behaving
want.
badly.
Yeah. I'm trying to like be cautious of how I say it too. Like exhibiting behavior that they don't feel is appropriate, right? Because that's also depends on the person. But that shouldn't be done, because if an employee or potential employee finds that out, they can also continue to use that in litigation, say they were discriminating against me. I didn't get this job because they went and looked on my site. Now, how someone would know this is IT, but err on the side of caution. You shouldn't do it. Now, I do know that, like, right, something like LinkedIn, right? That's public information. What you put on LinkedIn, I mean, if someone goes to your LinkedIn, I feel like there's a little bit more leniency with LinkedIn than being on someone's social media site that's like Facebook, Twitter, what are all TikTok, all of these other social media sites. And then your first question was non-competes.
Right.
And businesses having their employees sign non-competes. So yeah, employers can, outside of California, I want to say California's got its own thing going on. Professor Ikes, you can comment to
They
that.
do. California is a mess.
California's got different wage, overtime. I mean, yeah, California's very different in a lot of ways, but an employer can have an employee sign a non-compete agreement to protect their business. And typically you see that again in industries such as tech, right? I don't want you to take away our IP and you go from Apple to Google. This is also being something as simple as, Professor Ikes made a good example, maybe a sales associate keeping a book of business, like they have all of their current clients' information, and then they go to a business across the street with the same client information.
So,
and go ahead.
You can always have them sign it.
Yeah, I was gonna say, yeah, you can have them sign it.
Always have them sign it. However, it is not always enforceable. And you got about a 50-50 shot of having it be enforceable.
Yeah.
By and large, judges are not excited about enforcing these things, particularly if it in any way stops a person from making a living.
Yeah. I was gonna go there.
Now, I would say non-competes are different than non-disclosure agreements. And draw a very clear line. Non-disclosure agreements for trade secrets and other things like that, those are perfectly acceptable and they happen all the time and they are enforced. However, those non-compete agreements that you won't go to the other side and use your knowledge in your new position, yeah, that starts to get really tricky and judges don't like to enforce them as much.
Just to throw a little curveball in the mix of that, what if somebody were to leave a job and go start their own business in the same field?
And
a lot of those hiring agreements will say, much like a purchase and sale of a business, will say you can't go start up your own, there'll be some kind of 1 year or 2 year limitation. Judges are much more likely to enforce that 1 or 2 year limitation than they are to enforce something that says you may not do this ever.
Right. Okay.
Yeah. And I was going to add on to that too. I know there's a lot of litigation that's been going on too about non-disclosure agreements, about it being a tool to silence prior employees too. So it also just depends on what the non-disclosure or non-compete agreement is about. So also to just kind of draw the distinction
when it's a registered trade secret or something of that nature, non-disclosures are pretty easy to enforce. Because registered. So for example, if you have the KFC's secret recipe for their fried chicken, yeah, you can't take it over to Popeyes, right? That's not cool. They don't let you do that, and you can have a non-disclosure agreement.
Correct.
Well, I see that we are coming to the end here. It's 2:00 exactly. I don't want to keep you over, but I do want to thank you so much for all the information you shared. It was really just a plethora of really practical, helpful information. Do you want to say or mention anything else? I'm just trying to be respectful of your time.
I would say thank you to Jasmine. She really carried the weight for this and did an amazing job. So thank you, Jasmine.
You're welcome. And also, I
Thank you,
want to
Jasmine.
plug again VSEL. If any business is looking for any sort of business advice, this is something that we do at Vermont Law and Graduate School. And Professor Nicole Cloran, who is over the program, would be ecstatic to have businesses and or help and assist businesses who perhaps need some additional legal help.
I will double down on that, Jasmine. I tell and refer everybody that I work with to the Vermont Law School, for that's it's an invaluable service that was really missing in the business community. So I couldn't be more appreciative for all the help that the Vermont Law School is providing, and of course the classes that you're providing. It's just really, really helpful. So thank you so much.
Absolutely. Hopefully we look forward to seeing some businesses soon in the future.
Yeah.
And maybe we can turn off the recording now.
Yeah, sure.